Welcome to the DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law, or visit DeWittLaw.com. If you want to get your legal questions answered on this show, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are here every Sunday morning at 10 a.m. We talk about Florida's legal issues and how they affect you. I'm John Bustecker, and across from me is attorney Moe DeWitt of the DeWitt Law Firm. Good morning, Moe.
Good morning, John. How are you doing?
I am fantastic. I'm great because I am here with you.
Here with me on Memorial Day weekend.
We sure are. Yeah. We're doing the show. We're doing the show. We're not taking a vacation.
No, we're here.
That's right. And speaking of vacation, you have a amazing contest that you're running right now. Tell us a little bit about that.
Yeah, so we're doing a contest for any teachers out there because, being a teacher is a hard job these days. And frankly, a lot of people, left the teaching industry after COVID because it got so tough. So we want to try to reward the teachers out there. So we're doing a contest to basically where you can nominate a teacher. If you're a teacher, you can nominate yourself to get a free cruise, and we'll pay for a cruise for you. You just go to the website and register on there.
Yeah, just go to justcallmo.com. That's justcallmo.com. There's a link right on the homepage. You really can't miss it. It says win a cruise. And we're going to give that cruise away sometime later this year, but the deadline is June 30th. So you got a little bit of time, but get those submissions in because we're getting a lot of them. I've seen them come in. We're getting a ton of them throughout the state.
Yeah. First day, I think we got quite a few already. So got a lot of work to go through them all, and we'll pick a winner and send somebody out to the high seas.
And it's open to all teachers in Florida. You don't just have to live in Orange County or Seminole County or Lake County. It's all teachers in Florida. I think we said pre-K to 12th grade. So anybody teaching kids, we want to give them a cruise. So go to justcallmo.com and you can register for that contest.
Absolutely.
All right, Moe, we have so many questions that have come in over the last week or so. So we're gonna ask you questions today. All right, are you ready?
We'll see. I guess we'll find out.
I mean, you're like a genius when it comes to the law, right?
I wouldn't go that far, but
okay.
I can answer a question or few.
All right, and if you got questions, send them to ask@DeWittLaw.com. We'll get to them eventually, and we're gonna answer a bunch today.
Yeah, and you can also call the voicemail line at 407-536-6737. And leave a voicemail there, and we'll answer the question on there.
All right. So first question. This is from Dennis. And Dennis says, I've been separated from my wife for over 11 years. We divorced 10 years ago. We both signed the paperwork, but I never got to the courthouse to turn the paperwork in. What do I need to do to get this taken care of? Is it too late? And do I need to start over?
So we've actually had this situation arise before. I'm not sure how people manage to do this, but apparently it happens.
People get busy, Mo. People get busy.
So the question or the answer is going to be it depends. So first of all, we have to make sure that you did the paperwork correctly and that you have everything signed that you need to have signed. It also depends kind of how old the paperwork is. So we really have to go through everything. And then, of course, is your former spouse or soon-to-be former spouse still cooperative? So if they're still cooperative, it makes things pretty easy because, if you miss a signature here or there, we can still have them sign it. As long as the agreement's in place, we can get the other documents finalized. If they're not cooperative, if they've disappeared, actually the case we had before, the party that we represented didn't know where their spouse was, which made it much more difficult. Then if you don't have everything signed, it can become a little more complicated, and you may have to go through more of a traditional divorce route, where you have to have the other side served or attempt to serve the other side. So it can be somewhat problematic, but hopefully you did all the paperwork correctly. Hopefully you're not missing any signatures or missing any forms, and we can still walk it through as long as the paperwork's not too old.
What if the other spouse or the spouse got married thinking that she was divorced?
So we've had that case too.
Wow.
Actually. And the second marriage becomes invalid because you can't get married while you're still married, obviously. So that became a common problem when, for a time back in the 90s, I think it was, mid to late 90s, there was a a thing that kind of became popular where people would go to places like the Dominican Republic or these other countries, and they would do these quickie divorces. I think Michael Jackson actually did one.
With Lisa Marie?
Maybe. I don't remember who he did it with, but and that's what kind of popularized it. But they weren't legally valid a lot of times. They didn't do the paperwork properly. A lot of times the quote unquote courthouse was really just somebody's living room. The documents weren't kept properly. And so, people thought they were divorced, and then they go get remarried only to later find out, whoops, that divorce was not legally valid here in the U.S. So that didn't really work.
Okay.
It created a lot more problems.
So basically, if you're going to get divorced, do it the right way. If you live in the United States, maybe get it done in the United States and contact an attorney.
Yeah, and sometimes people think they're pulling a fast one where, I'll go to Dominican Republic, or I think Mexico was another one, and they'll get divorced and they'll just have all the assets awarded to them, and they think it's legally binding. But it just doesn't hold up. I mean, you're not tricking anybody. The U.S. courts are not going to recognize something like that when it doesn't afford the same due process to the other side, the same forms of notice and things like that. So, yeah, it ultimately doesn't hold up. And then, of course, if you get remarried, it causes even more problems. So,
all right, Mo, next question.
all right.
This person didn't leave their name, but they say, I live in Orlando and I've been dealing with a persistent neighbor dispute that is affecting my quality of life.
Good old neighbor disease.
What legal recourse do I have to resolve the situation and restore peace to my neighborhood?
So, I mean, neighbor disputes can be tough, and obviously they don't give us the details here. We need a lot more details as far as what the actual neighbor dispute is. But I think there was a couple years ago on the show, we talked about a case where the neighbor put a camera above their home, and the camera was actually up on like a pole like 17 feet above the house and aimed directly into the other neighbor's yard.
All right.
And, it went through the whole court process, and ultimately the neighbor whose backyard was being recorded got an injunction requiring them to take down the camera. But obviously it can be quite messy, and there's a balance there where you have the right to have surveillance cameras, but when you put a camera that's for the sole purpose of seeing in someone's backyard, and there was really no other argument that the camera could be for anything else, I think they made something up.
That seems a little shady.
Yeah, I think they said it was for surveillance or overhead, something or another, but it just didn't add up. And so ultimately the court made them take it down. But, typically you can't really get injunctions or restraining orders against your neighbor because they live next to you. So you can't make them move 500 feet from you because that would be violating their constitutional rights and their property rights and so on and so forth. So things can get a little messy, obviously. I'm sure, the police officers out there, that's probably one of the things that they hate dealing with because it's probably not the best use of their time. But yeah, depending what the dispute is obviously you're gonna have to deal with it, based on those facts. But typically my recommendation is just avoid the neighbor as much as possible.
And that can be easier said than done, but yeah, you're right. Yeah, if you can, maybe just try to avoid that person.
Yeah, I mean, I've had some bad neighbors before. That was kind of my strategy, is avoid them, ignore them. If they try to egg you on, you just ignore them and go the other way.
But you've never been a bad neighbor, right, Mo?
I don't think so.
All right. Next question for you. And if you got questions, send them to ask@DeWittLaw.com. We'll try to get to them maybe on next week's episode. So this is from Ralph. He's a small business owner in Mount Dora.
Okay.
He says, I'm facing difficulties with a vendor who consistently breaches our contract.
Okay.
What steps can I take to protect my rights and seek appropriate remedies for the damages caused?
Well, if he's consistently, breaching the contract, the first thing you can do is stop doing business with them, or, require payment up front or change the terms. You can have a new contract put in place that provides more security for you, whether it's a security deposit of some kind or payment up front, that just modifies the terms that are more in your favor to help hopefully prevent the ongoing breaches. Now, of course, it depends on the nature of the breach, exactly, what exactly is going on. But the other option is just to stop doing business with them altogether and then sue them either in small claims court or circuit court, depending on the amount, and ultimately go after them for whatever they've done or whatever they haven't paid for.
Real briefly, how does small claims court work? Is it up to a certain amount that you're allowed to sue for? And do you have to represent yourself?
No, you can have attorneys in small claims court, but small claims court is usually, I think it's under $5,000. And it is somewhat of a modified proceeding where it's a little more simplistic. Typically what happens is once someone files a lawsuit, they have what they call a pretrial conference, but typically that's more of a mediation. You kind of do a little mini mediation where you try to resolve the case or settle the case. And then if you can't settle it, then you go see the judge, and the judge sets it for like a mini trial, essentially.
Is it like Judge Judy?
Not quite like Judge Judy. I don't think the judges are that offhanded or make those kind of remarks like Judge Judy gets away with. But
All right, Mo. Next question for you. This is from Emily. So I recently had a slip and fall accident at a local grocery store in Kissimmee due to a hazardous condition. How can I pursue a personal injury claim and ensure fair compensation for my medical expenses and other losses? She sounds like a lawyer.
yeah, exactly. She's done some Google research already. I mean, anytime you're in any sort of injury case, you want to document it. That's gonna be the most important thing. So, if you can, if you're not too injured, or if you have a friend or somebody with you, you want to take pictures of the substance on the floor. You want to, of course, notify the store right away. Make sure that you preserve any video evidence. Video evidence in slip and falls becomes very important because in Florida, at least, you typically have to show that the business owner either knew the substance was on the floor or should have known the substance was on the floor, meaning that's been on the floor for an extended period of time and they haven't taken reasonable measures to clean it up. So what that typically means is that you have to look at the video surveillance, not only for where the incident happened, but for the entire store. So, do they have a policy and procedure, depending on the type of store, of course, of, going around, looking at the floor, walking around the aisles, making sure things are cleaned up? Or, does the surveillance video show that an employee saw the spill and just stood over there, on their cell phone for 20 minutes?
Not my job. This is somebody else's job.
Yeah. Or did an employee actually cause the spill? Were they the ones who spilled it and failed to clean it up? So, that evidence becomes very important in slip and fall cases, which is why it's so important to get the video surveillance, like I said, not only for where the slip and fall occurred, but the entire store. So you can see, okay, how many people are going in and out of the store? What are the employees in the store doing? All those types of things. And so, that's going to become very important. Now, as far as, getting fair compensation, no attorney can ever guarantee any sort of compensation, but you want to make sure that you go to a doctor, depending how injured you are, of course, and get checked out and follow the doctor's advice, because most cases are going to be based on your medical treatment. That's really what really drives the fair value of a case. So I've had cases before where the guy goes, "Oh, I'm in so much pain. I'm so hurt. I can't do this. I can't do that." I go, "Well, go to the doctor. Have you told the doctor?" "No, I'm too busy to go to the doctor." Well, then you don't have a case, right? Because any reasonable person, a jury's going to look at a reasonable person, is going to go to the doctor and get some sort of treatment.
Especially if you're hurting. If you're really hurting,
yeah.
I mean, I get it. I mean, I've been that person that's like, "Oh, I'm fine." But if you're really hurting, and sometimes you are really hurting, but you still got to go to the doctor.
Right. Especially if you want to bring a case for it, right? I mean, if you want to bring a claim, you have to show that that the injuries are documented by a medical professional. If you don't do that, it's really going to hurt your claim.
How do you get the surveillance footage? I mean, do you have to go over there and be like, "We want your surveillance footage"? How does that work?
Typically, we just send a letter. So we send a letter, both regular and certified mail. It's called a spoliation letter. And basically, it puts them on notice to preserve all of the evidence that we're requesting. And if they don't do that, there can be adverse consequences to them in a future lawsuit. So no, we don't have to physically go down there and demand it. We just send them that letter that preserves it. Now, typically in those cases, they won't actually give us the video until we file the lawsuit. Most companies at least follow that policy, which can make things a little difficult for evaluating pre-suit. But then once we file the lawsuit, we're typically entitled to see that video.
So, Mo, that's probably why it's important to see an attorney right away, because they might not have that surveillance footage 6 months. So don't wait 6 more months to file your claim.
Yeah, I mean, you really need to put them on notice right away, because a lot of places will only have video for 2 weeks, 30 days typically is kind of the max. And once that video is gone, it's gone. You're not getting it back. So if you wait to put them on notice, if you don't send the notice to the right place, if you don't do it properly, you could be waiving your ability to preserve that evidence, which is really crucial to your case. So, yeah, you absolutely want to make sure you do it properly and as soon as possible to make sure you preserve as much evidence as possible.
All right, Mo, we got to take a little bit of a break, but if you got questions, send them to ask@dewittlaw.com. We will try to answer your questions, and we'll be right back.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, And he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400 basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. We are talking about Florida's legal issues, and we're answering your questions. If you have legal questions, send them to ask@dewittlaw.com. That's ask@dewittlaw.com. You can also visit DeWittLaw.com if you have any legal issues. You can also call the DeWitt Law Firm at 1-800-DeWitt-Law. I'm John Busdecker. I'm here with Moe DeWitt. We're asking questions. Moe, are you ready for another question?
Let's do it.
All right, let's do it. This is from Samantha in Sanford. That just rolls off the tongue. Samantha in Sanford.
Yep, alliteration.
So I've been dealing with a difficult landlord who refuses to make necessary repairs in my rental unit. Can you advise me on my rights as a tenant and how to address this legally?
So first of all, you want to put them on notice in writing. That's the mistake that a lot of people make, is they don't actually, put the notice in writing. They just call and complain. But if you don't put it in writing, you don't really have the proof you need if you were to ever end up in court. So you want to send them a letter, both regular and certified mail, specifically outlining the repairs that need to be made, what's going on within the unit and what effects it's essentially happening or having. From there, you have to be very careful about withholding rent. Because if you withhold rent, they could evict you. And depending on what the issue is, you may or may not be entitled to withhold rent. So we need to know the specifics as to what's going on within the unit as to whether you're allowed to withhold the rent or not. But assuming that you put them on notice and they still don't repair it, then you could eventually bring them to court if they refuse to fix it, or if it is an issue that you're allowed to withhold rent for, you could withhold rent or make the repair yourself and deduct it from the rent. But you got to be very careful when doing that. It does depend on what the issues are. You can't just make unilateral repairs and say, oh, there's a paint chip here. I want to repaint the walls. I'm going to deduct $200 from the rent. It doesn't work that way. It's got to be something fairly substantial in order for you to be allowed to withhold rent.
And I would guess in Samantha's case, same thing. Probably a good idea to take photos, take video,
absolutely.
All that stuff.
Yeah, you want to document. I would say document everything as if you're ending up in court. Hopefully you never do, but prepare your situation like it's a case that's going to court. And that way, if you do end up in court, you'll have all the information there.
All right. This one's from Emily. She lives in Winter Garden over in Orange County. If you're not familiar with Central Florida, if you're listening to the podcast later on, maybe you live in Hawaii or something like that. We got fans all over, Mo.
All over the world.
That's true. All right. I recently got in a car accident and the other driver doesn't have insurance. What are my options for recovering damages in such a situation?
Well, as we've talked about on the show before, Florida is the only state in the nation that does not require bodily injury coverage, which means that someone can legally hit you and hurt you and not have insurance to cover it. So it can put you in a tough spot. So that's why I always recommend that people have uninsured motorist coverage on their policy. If you don't know if you have it, call your insurance agent and ask them. I would recommend adding it. It's usually not very expensive to add. But in a situation like this, the only remedy you really have is to sue that person personally. And now typically, most people, especially if you're driving without insurance, are not going to have any sort of assets to go after. So while you can go get a nice piece of paper that has a judgment number on it, and you can frame it and hang it on your wall, it's not going to do you any good. And you're going to have to go through the whole court process and spend more money on that, throw good money after bad, as I like to say. So it can be a very difficult situation. But the only way to protect yourself is to make sure that you personally have the right insurance to cover yourself if this ever happens to you. Now, there are a few other things you can do in these situations. Sometimes we will file suit against the individual who doesn't have insurance to see if maybe they were on the job at the time or doing an errand for their employer, basically looking to see if there's any other insurance policies that could possibly apply. Obviously, you're kind of looking for a needle in a haystack in those situations, but sometimes it does work, and that's why we investigate it further that way.
Now, if somebody like that didn't have insurance, is there anything else you can go after? Let's say they don't have $10,000 lying around or whatever. Can you go after their house or anything like that?
Well, typically their homes are protected by homestead in Florida, so you can't go after that. Unless there's substantial assets, a lot of those assets are protected. So you can get a judgment. Maybe you can garnish some wages over time. But it's a long and difficult process where you're never really going to be made whole, frankly.
All right, Mo, we got to take a quick break. But if you got questions, send those to ask@DeWittLaw.com. That's ask@DeWittLaw.com. And we'll be right back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. We are answering all of your questions today. I got Mo DeWitt with me. I'm John Bustecker. If you have legal questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. And if you want to visit our website, it's DeWittLaw.com, or call our firm. It's 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. Mo, what were you doing during the break? Hanging out?
I was studying up. Reading these legal textbooks over
All
there.
right, I saw you on your phone, so.
Well, I keep all the legal textbooks on my phone now.
All right, you still look at your old legal law books when you were in college?
I don't even know where they are.
No, you don't need them. You got it all in your brain.
We try.
All right, Mo, you ready for another question?
Let's do it.
All right, this is from Robert. He lives up in Apopka.
Good old Apopka.
Yeah. So here we go. My neighbor's tree branches are hanging over my property and causing damage. What are my rights and responsibilities in this situation, and how can I resolve this issue without causing a conflict or maybe a legal conflict?
Yeah, so typically you can trim the bushes or the tree limb back to your property line. It will be at your cost, but you're welcome to trim that tree back to basically the property line there. Now, assuming that the tree is healthy, there's nothing more to really be concerned about. But if it was an unhealthy tree that needed to be removed, then you could put the neighbor on notice that, hey, this tree is dying, essentially, you need to remove it. And if they fail to remove it, then they could be liable for any damage that tree causes.
So if that tree were to fall onto my property, it's my neighbor's fault at that point?
If you put them on notice that it was a dead tree. If, let's say, a storm came through, it was a healthy tree, and just came down onto your property, then it's not his fault. Then you have to remove the portion that's on your property. He removes the portion that's on his property.
But anything that hangs over into my yard, I can sort of shear off if I want to.
Yeah, you can trim it on back.
I mean, I'm not gonna lie to you. That sounds like a neighbor conflict waiting to happen. But I get it.
Well, and the good thing to do, or the proper neighborly thing to do, would be go talk to your neighbor before you do that and say, hey, this is causing some issues. I'd like to trim it back. Maybe they'll offer to split the cost with you. But at the very least, if they don't, you can still just say, hey, I really need to trim this back because it's causing some damage to my house, rubbing against the roof or whatever it may be, and go ahead and trim it back.
All right. So this one is from Jessica. She lives in Windermere. Sounds nice. You been to Windermere?
Area.
You been to Windermere, Mo?
I mean, no offense to anyone who lives out there, but I try to avoid that area because the traffic is just horrendous out there.
So you're right. Until you get to actually in Windermere, like the town of Windermere, it's very quaint there. Their roads are made of dirt. Did you know that?
I did not know that.
Really?
No.
Yeah. Some of their roads are made of dirt.
I guess I've never made it that far.
Oh, really? You just turned around?
I turned around once I hit the traffic.
Okay. All right. So this is from Jessica in Windermere. I recently adopted a child, and I want to ensure that all the necessary legal procedures are followed. Can you guide me through the adoption process, I guess post-adoption process, and any legal requirements involved?
So adoption is not something that I do. There are specialized attorneys in town who deal with adoption. So if you want to give us a call, or we'll reach out to you and get you some of their names. And they, that is kind of a specialized area of the law, with not only the adoption planning process, but actually making sure the adoption is done properly. And then depending on the circumstances afterwards, there may be certain legal documents that you need to file to make sure everything is done properly and that there's no issues down the road with school registration or anything like that. So we'll certainly put you in touch with somebody who handles that. It's just not really my area.
All right. So if you want to call, it's 1-800-DeWitt Law. That's 1-800-DeWitt Law. That's the number to call.
Yeah, 1-800-339-4885. Because I know some people get confused when you spell out DeWitt Law. It's actually more than 7 numbers. But yeah, it's 1-800-339-4885, which does translate to 1-800-DeWitt Law.
All right. Or you can go to DeWittLaw.com, and all the phone numbers are on there as well.
Yep.
All right. So this is from David. He lives out in Claremont.
Okay.
You been to Claremont, Mo?
I have been to Claremont.
All right. It's over in Lake County.
Less traffic.
So I'm considering filing for bankruptcy due to overwhelming debt. Can you help me understand the legal procedures behind bankruptcy?
Well, there's different types of bankruptcies, obviously. And, I always look at bankruptcy as kind of a last resort. Depending on the type of debt that you have, it may be worth trying to work out some sort of payment arrangement with the individual creditors. But it depends just if that's even feasible at this point where you are. But a lot of times if you reach out to them directly, depending on the creditor, they may be willing to work with you. Assuming they're not, then you're going to look at the bankruptcy route. And there's different types of bankruptcy, like I mentioned. There's Chapter 7, where you're basically discharging the debt, and you have to qualify for that based on your income to debt ratio, essentially. I'm speaking kind of in generalities here.
Mm-hmm.
Again, we don't actually do bankruptcy in our office, but if you do need help with a bankruptcy, we can put you in touch with someone who handles that kind of work. But basically, you have to qualify for Chapter 7. You go through the process. You list all of your debts, all of your assets, and ultimately, a lot of those debts are going to be discharged if they can't be paid from your assets. Chapter 13 is more of a restructuring, where you're kind of put on a court order payment plan. I think some of the debts are reduced to a certain amount, but you're kind of paying them back over a couple year period, typically, until those debts are satisfied. So again, it's something that you want to sit down with a bankruptcy attorney and really go through in detail your specific situation, how much you owe, if it's possible to work it out with the individual creditors. If it's just one credit card and maybe you owe 10 or 15 grand on it and you just can't pay it, a lot of times if you reach out to them, it depends on the bank. Some banks are easier to work with than others. But if you reach out to them, a lot of times they're going to shut the credit card off, of course, but they'll be willing to make some sort of payment arrangement with you because they really don't want to have to sue you. And of course, if you go to bankruptcy, they could get a substantially reduced amount or nothing at all. So a lot of times they're incentivized to work with you from that case.
Can you just yell out, "I declare bankruptcy"? Does that work?
Michael Scott tried that in the office, but I don't think it was legally effective.
Okay, all right, just checking.
Yep.
You got the legal mind over there, Mo, so I just want to be sure.
Of course.
All right, here we go. This one's from Brian. He's calling from Lake Nona, or he's writing a letter from Lake Nona. I recently received a traffic ticket, but I believe it was issued unfairly.
Okay.
Can you advise me on the best course of action to challenge that ticket and defend my case in court?
So I've recently gone down a rabbit hole of internet videos of people getting pulled over and
Okay,
and yelling.
That's no good. That's usually no good.
No, it's not. But it's interesting what people think is unfair. The one I watched actually this morning was the lady told the officer that she legally did not have to have a driver's license to drive a vehicle and would not produce the driver's license.
Okay, that's one strategy.
Yeah, you want to guess how that turned out?
She either got ticketed or taken to jail.
She got
probably
taken to jail.
All right.
So yeah, not a good strategy. So the first question would be, why was the ticket unfair? Unfair and being illegal or improperly issued are two different things. So typically within a ticket, you have a certain amount of time to challenge the ticket. It's usually listed right on the ticket, the citation itself, depending on the type of citation that it is. And then you're usually assigned a court date, and you can go into court and basically plead your case to a judge, and a judge will make a decision as to whether it's unfair or not. Sometimes you can get hit with additional court costs and things like that if you lose in court. But if you win, of course, the ticket may be wiped off and erased, essentially.
I got a question for you. This happened to me, actually.
Right.
So it's not just our listeners that get to ask questions. I get to ask them too. When I was like 20 years old, I actually got a ticket for running a stop sign,
Okay.
but it was in a parking lot. And I didn't think that was fair. I mean, I did run the stop sign, but I didn't know they had jurisdiction in the parking lot. Is that, I mean, can I get a ticket for that? I mean, I got a ticket for that,
Yeah.
but could I have fought that?
I mean, I think it depends on the individual jurisdiction and how, a lot of times private property, they, like if you have a car accident on private property, for instance, police won't come out because they don't really have jurisdiction because it's not a public roadway, essentially. There they may have an agreement or a contract with the local authorities saying, hey, you can police this area and we want you to enforce the traffic laws. I mean, it is still a stop sign. It's still a roadway. It's just not a public roadway. So that's where the jurisdictional issue comes into play.
Okay. All right. I think I showed up for court and the police officer didn't show up, so I got it dismissed.
That's one way to win.
Yeah. It felt like a win, I will say. All right. We got time for a few more questions, Mo.
All right.
This is from Jennifer in Winter Springs. Have you been to Winter Springs, Mo?
I'm sure I have.
Okay. All right. I'm going to just keep asking you where you've been in Central Florida.
Gonna have to get one of those maps on the wall with little thumbtacks of every city, every area in Central Florida. I've
That's
been
true.
to.
Maybe over the course of the next few shows, we can fill up that map.
Let's take the show on the road.
Oh, we should.
Yeah.
We should. All right, here we go. This is from Jennifer. I've been a victim of identity theft, and it has caused significant financial problems for me. What legal actions can I take to protect myself and recover any damages?
So identity theft's a tough one because you're probably never really going to find the person who actually committed the identity theft. Maybe they will, but from a civil perspective, there's probably not much to go after.
That's a downer already, Mo.
Right. They're a criminal. I mean, so if you catch them, they can be criminally prosecuted, and there may be some sort of restitution that is awarded as part of any criminal conviction. But typically it's very hard to collect from those individuals because they typically don't have any sort of assets to go after. And identity theft can be a royal headache. I mean, it can be very difficult. It can mess up your credit. And really, you just have to spend hours on the phone trying to clean things up, writing letters to the credit agencies, disputing things. I think there are some tips and techniques into how you write the letters because a lot of times they are read by kind of robots. And if they have certain elements in them, it kind of puts them in one pile. If they don't, it puts them in the other pile. So it would probably be worth doing some research on those issues. But from an actual legal perspective, I mean, it's really more of a criminal complaint that you would want to file. And then if they're able to find the person, then of course they can criminally prosecute them. But from a civil perspective, there's not really much that you are going to recover.
It seems like good advice, though, is to keep tabs on either your credit card, your debit card, your checking account a lot, because then you can spot it at least right away, and you're not going to get drained over the course of 60, 80, 90, 100 days if you catch it right away.
And that's the key, is catching it right away. I mean, I think we've all probably at this point had our credit card stolen or used illegally. It's just a matter of turning it off right away before it really, mounts a lot of charges up. The other thing is, typically it's better if you have a credit card that gets stolen versus a debit card, because if they overdraft your bank account, it can be take a lot more time to get the money back. There can be overdraft fees, and it can have more substantial damage to you personally.
Yeah. And I've had that situation where somebody used my debit card, and I'll be honest, in my situation, the bank was pretty good about it.
Yeah.
I caught it right away and went into the
key.
bank, and they turned it off, and they refunded me because they knew I didn't spend the money. But it wasn't thousands and thousands of dollars. It was just hundreds of dollars.
Yeah. I mean, I had a buddy of mine who was in Europe for a period of time, and somebody stole his debit card here. And when he got back, he discovered it, but it had been months. And so the bank was like, well, you didn't report this. And then he had to go through a whole process with the bank, and it became kind of ugly. So,
Oh, wow. Yeah, no, that does sound like a nightmare. All right, Mo, we got time for another question. All right, this is from Daniel in Winter Springs. Also in Winter Springs. Maybe he knows Jennifer from Winter Springs.
It's a big town over
Yeah,
there.
it is a pretty big town. All right. I'm currently going through a divorce and concerned about child custody and arrangements. What factors do the courts consider in determining custody, and how can I protect my rights as a parent?
Okay. So with any, divorce case, child custody case, basically the courts are looking at the best interest of the child, but there are specific factors that you can go read in the statute. I think it's 13 factors, maybe it's 15, I forget the exact number. But you can read through those factors, but ultimately it boils down to what's in the best interest of the child. So they're going to be looking at things like how involved is each parent? Do the parents cooperate? That's one where people get in trouble a lot, where they're constantly arguing with the other parent, and they're doing stuff that's not in the best interest of the child. and ultimately that can come down and kind of punish the child, or excuse me, punish the parent for and restrict the time sharing with the child. So you ultimately, whenever you're making any decisions, when you're going through a case like that, or even if you're in an argument with the other parent, you have to kind of ask yourself, what is in the best interest of the child? And sometimes, what you want to do may not be the same thing as what's in the best interest of the child. And so a lot of times people get in trouble for, unilaterally withholding a child. They'll say, oh, I don't think you should go to mom's house or dad's house because he doesn't feed you the diet that I think you should have, or because X, Y, or Z. They just kind of make up reasons. And when you get in front of a judge, judges do not like that. Judges want to see that the child that the parents have the ability to foster a relationship with both parents have the ability to foster a relationship with the child and communicate about the child. You don't have to be best friends, but you have to be able to kind of communicate when it comes to, hey, Tommy's got soccer, this week. Tommy's, whatever it may be, so that the child can live as much of a normal life as possible. I mean, a lot of parents get divorced; they're not together. That's not that uncommon. What affects a child is when the parents are constantly arguing and they're put in the middle of it. So that's what you really want to avoid. And then, as far as protecting yourself, if the other parent's doing something like that, you want to document it as much as possible. Keep a calendar. If you have to have communication in writing, do it that way by a text or email. And like I said, just kind of prepare yourself for that case, protect yourself.
All right, Mo, we got to take a quick break. But if you got questions, send those to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We will be right back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. We are answering your legal questions. Mo DeWitt from the DeWitt Law Firm is across from me. I'm John Bustecker. If you got questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. And you can always visit the website, DeWittLaw.com. Mo?
John,
you ready for some more questions?
Let's do it. That's what we're here for.
I got one. This one's from Josh. He lives in Oviedo.
Okay.
Have you been to Oviedo?
I have been to Oviedo.
All right. Me too. There's a pinball lounge out there. Fun place if you've never been.
Okay, I'll have to check it out.
All right, here we go. This is from Josh. I'm going through a divorce, and I recently discovered that my soon-to-be ex-wife has been saying some really nasty things about me to my daughter. Is there anything I can do legally?
So, first of all, ask your ex-wife not to do that, of course, and put that in writing. That's what we call parental alienation, or can be parental alienation, depending on the level that it rises to. And so those can be very difficult cases because basically what one parent is trying to do is alienate the child from the other parent. They're saying bad things about the other parent to try to gain favoritism, to get the child to maybe say that they want to spend all their time with that parent. Whatever the motive may be, it can be quite harmful to the child and to the child's relationship with the other parent. So if it continues, then you may have to file a motion with the court to basically ask that the court order the parent to stop doing that. If they continue to do it, then their time sharing may be restricted and there may be other consequences for that kind of behavior. Now, sometimes, when we're dealing with a child like that and parental alienation like that, we may have to get a guardian ad litem involved. And so, typically courts don't want a child to have to testify in court. So in a situation like this, where you have one parent kind of bad-mouthing the other parent to the child, the main witness, of course, is the child. So how do you prove it? Because, the parent who's saying it, of course, is going to deny it. The parent who's, being bad-mouthed is going to say, well, no, he is saying bad stuff about me.
Mm-hmm.
So then you have to get a guardian ad litem involved who basically represents the child and will interview the child and kind of do a report and recommendation. And so depending on, a lot of times when there's parental alienation, they may try to coach the child. And so the guardian ad litem, a good guardian ad litem will be trained to kind of help work around some of that coaching. So it can be a very difficult situation. It can be costly. It can be time consuming. But parental alienation can be very damaging to a child. And so you may need things like reunification counseling, basically where the child and the parent who is being badmouthed kind of go to counseling together to kind of work through some of those issues and hopefully rebuild that relationship.
What if instead of saying things to a daughter or a son, what if that spouse is putting some of this stuff on social media?
Well, typically we still have a right to freedom of speech, right? So you can badmouth the other parent or your ex-spouse as much as you want, as long as it's true to some degree, because you could be sued for libel or defamation if it's not true. So there are certainly those consequences. But if you just really don't like your ex-spouse and you want to complain to them, to your friends, you're certainly kind of allowed to do that. Now, we have had cases before though where one parent had time sharing that week and the other parent put up a fake Amber Alert on social media.
Really?
Saying that the other parent shouldn't have time. What they were trying to say was that the other parent shouldn't have time sharing, that the child was stolen from them. It was obviously very extreme and the judge did not like it very much once it got to court on that. So, you have to be careful what you do. Assume anything you post on social media is going to end up in court in front of a judge, and kind of think to yourself, how would a judge view this?
Yeah. And I think you've talked about this before. Like, social media is real life. And so like the things you put up there, people can see.
And they can have consequences.
Yes. Yeah. And so if you are going to do that, think about your choices, what you put up online.
Yeah. Like I said, just assume anything, anytime you send a text message, post on social media, leave a voicemail, anything involving, an ex-spouse or a custody case or time sharing case, just assume that that's going to be put in front of a judge and kind of think to yourself, is that a good idea?
All right, Mo, we gotta get going, but can you tell us one more time about this cruise contest that you're doing?
Yeah, so we're giving away a free cruise to any teacher in Florida. If you're a teacher, if you want to nominate a teacher, you can go to justcallmo.com. You'll see a big button on the top of the screen that says free cruise. Go ahead and nominate them. I think we have till June 30th to do that, and then we'll be picking a winner.
All right, Mo. I hope you have a good holiday weekend.
You as well. Have a safe Memorial Day.
Will do, and we'll see you guys next week.
So I still can't believe how many times people ask me, how do you get paid on accident cases? Well, we work on what's called a contingency fee. So basically, we only get paid if you win. If we recover money for the injuries you sustained in an accident, we get a percentage of that. Usually that's a third pre-suit or 40% after a lawsuit is filed if the other side denies liability. It's a pretty standard rate in the state of Florida, but again, we only get paid if we win the case. Otherwise, it does not cost you a dime.